Today's session is on ADR and ODR. ADR is, people say it's alternate dispute resolution, and some prefer to say it's appropriate dispute resolution. My lawyer fraternity prefers to call it alarming decline in revenue. But that's besides the point. The main thing is that we are here for the parties who come to us for getting some robust resolution for the disputes. And therefore, you will notice that in any given situation, we have before us several options. And you will also notice that one can resolve disputes also in numerous ways. We can consider getting just a settlement of our issues for the day, as also we can consider doing a more insurgent operation where we go right down to the roots of the situation and unroot it from right below the earth. And these scenarios help us to not only deal with the issue at hand today, but also help us to have that mindset which have a response from us the next time a similar situation arises, to go for a rather collaborative approach instead of what we are used to being a reactionary approach or a litigious approach or an adjudicatory approach. And you will notice that situations are always potent with opportunities. It's for us to notice them and grab them with both hands. Moving on to what is the appropriate mechanism for the dispute at hand, I am reminded of late Professor Peter E.A. Sander, God bless his soul. He was a professor in Harvard Law School and very much involved from the initial stages of the Pound Conference that started with the mediation culture in the US. And he has this oft-quoted line, see what fits the fuss. So first you need to identify what is the real fuss that you are in or what you want to deal with, and only then you may want to consider the appropriate mechanism. Now, firstly, you need to understand this, that ADR is more about R, which is resolution, and not ADA, which is adjudication. So when we are looking at mediation, we are looking at a resolution rather than an adjudication. And the difference lies in this, that once you have a resolution, then you don't need to do anything more. People often ask me this question in mediation, that how do you say mediation is better than arbitration? In arbitration, we at least have something binding, something final, and something enforceable. In mediation, yes, it's true. You do not have anybody telling you what is the final word and making it enforceable. And at the same time, it gives parties the opportunity to carve out for themselves what they consider to be the best way out to meet their future interests. If you are in a court of law in a litigation, or you are before an arbitrator in an arbitration, neither forum can help you in achieving your interests, for the simple reason that they are and are supposed to be only focused on what happened when and what was the applicable law then. That being so, they can only look at the past, whereas mediation talks of looking at the future, your future interests. And that's where lies the charm of mediation. Secondly, people talk also about this enforcement issue. And there you will note that you choose the clothes you want to wear. Nobody enforces anything on anybody. And in the same way, when parties go for a mediation, unlike an arbitration, where once you enter, there has to be some decision at the end, some agreement at the end. No, in mediation, you may choose not to settle. And that's also good enough. I may share one personal anecdote of mine, that some organization asked for my statistics of success in mediation in a certain area. I gave expectedly some 20-30% as my success rate in that field. And I was surprised when I was informed later on that it's 50% plus. And when I tried to identify where things went amiss, I was told that no, you are right, in 20-30% is what would have been the range of your success rate initially. But we consider it as a success rate even if parties come and settle after a month or two of the mediation having ended, and that we ascribe to the mediator's skills of getting parties talking. Charm of mediation is not just in the process, but sometimes due to whatever reason, like for example, you will find always in the court annex system, we are given only 90 days now in the commercial courts cases and are given about half that amount in section 89 cases. Therefore, we have to put in our report if parties don't settle, or even if they say we want to settle, but if our time is out, it's out. And in such scenarios, definitely this would be a reality that parties don't settle in front of you, but then they keep talking and they settle later on. So the benefit of ADR is that you get a resolution, and once you have a resolution of your own free will, then parties do not require anybody else to tell them what they should do. In fact, I have had instances of lawyers trying to scuttle the mediated settlement by saying, "Arey, मैं इससे ज़्यादा दिलवा देता था." And the parties would themselves turn around to their own lawyers and say, "Yes, and in the present circumstances, if I am getting something today, when I have my teeth to chew, then it's better to get peanuts than to wait for the almonds that I could get from through you when I don't have any teeth remaining." So parties do see the value of getting a resolution today rather than waiting for God knows how long. Now, once you know what sort of a situation you are in, you can then choose the appropriate mechanism. All sorts of scenarios, negotiation is the default way of going about things. However, lawyers have been known to sometimes even not allow that to happen. In one case, the party did say that, "Oh, he is my friend, I'll talk to him," because the lawyer said someone has sent you a notice. And when he said, "I'll talk to him," the lawyer said, "No, you will do nothing of the sort, because if he was really your friend, he wouldn't send this notice. And now his lawyer has sent the notice, so I will answer it. You are to not even contact him." Later on, after 2.5 years, when the matter was taken up in court and then referred to mediation, in that very first meeting, they resolved the issue only because they spoke to each other. So negotiation is a good thing, but we need to be mature about it and have an early intervention to go for it. Nowadays, of course, in all the commercial contracts and especially the big, huge contracts, they do have a multi-tier clause which says that first the CEO of party A and the CFO of party B would talk it out and negotiate for 15 days. If nothing happens, they would move on to mediation. So now that sophistication has come in fact, it's even more in some jurisdictions, but we have not yet reached there. So let's keep that for the moment. Next thing, that should the negotiations not fructify, usually we do have parties going to their lawyers and getting notices sent. But really speaking, even in some jurisdictions, like even in India now, even if you do send a notice saying that I will sue you and try to sue the other person, you would be required to go for some collaborative process. In India, we have mediation under the Commercial Courts Act. So you do have several options. I mentioned conciliation next only so that I can deal with it right away before we move on to more interesting stuff. Conciliation, neo means in the present day as we are to understand it, not in the traditional way. In the traditional system in India, we had something called, similar to conciliation, it was called lavad. Now, the situation with lavad is that it is very similar to what is presently practiced in some tribunals in Australia, especially the rent tenancy, landlord-tenant cases, and that tribunal sits on the matter, tries to mediate, and if they cannot, then they pass some order at the end which should be binding on the parties. And that is one way of looking at conciliation, and that's not what we do in India. So that traditional style which still happens in Australia is not something which we do here. Here, when we talk of the present day conciliation as to be understood from the Arbitration and Conciliation Act of 1996, Part 3, Sections 61 to 81, there you will find that people have a varying interpretation of what the conciliator can do and cannot do. But suffice it to say that the conciliator is a mediator. There is no difference in the two processes. Yes, there are certain nuances, and yes, the conciliator is allowed to make some suggestion, but then again, that suggestion is not binding on the parties. Parties may choose to. Now, the wordings over there are a little to be understood a bit maturely. That though the statute provides that the parties may then make some changes and all that, but the reality is that parties can ignore it totally and come up with their very own agreement, and the mediator or the conciliator has to just take it on record and see whether it falls within the ambit of what we call ZOPA, that is zone of possible agreement. And once that is so, that is, even the four corners of law are kept well balanced, we are within the four corners of law, then definitely the issue, the dispute would stand resolved through conciliation. And the benefit of this 96 Act is that you can even have enforcement of this very same mediated settlement agreement, which we call a conciliated agreement. Moving on to settlement conference and expert determination and neutral evaluation, non-binding arbitration, collaborative practice, all these are not available today in India, but very soon one hopes they will land on our shores. We already have some people doing neutral evaluation. I know one gentleman, senior counsel, he is a neutral evaluator. And that's this peculiarity of non-binding arbitration I found very interesting, that we spend so much of time, money, effort in arbitration, that when I was informed that there is something like non-binding arbitration in, I think, the state of California, I had to ask that what is the point of having it non-binding after going through the whole rigmarole. So yes, we do also have judicial arbitration. We also have the regular arbitration. Non-binding arbitration, the difference is one small at the end, that at the end of the whole process, unlike a regular arbitration which would be enforceable in court, in non-binding it is both the parties who have to make the proactive effort of jointly approaching the court to make it binding on them. Otherwise, it remains non-binding. And the answer to the question as to why then bother with the whole expense and effort was that these non-binding arbitrations open the eyes of parties widely and allows them to see reality, which would prod them to come to the negotiation table or go for a mediation and resolve amicably whatever be their dispute. So it's a good thing, a lot of expense, but worth it if you can deposition the parties by opening their eyes through all the rigmarole of the whole gamut of evidence and submissions and all that. Non-binding arbitration also is a good step. Collaborative processes also. Coming now next to the collaborative practice of law, that is something which we do not have in India. It's something which was started by one gentleman called Stu Webb, S-T-U-W-E-B-B. Stu Webb felt that the divorces in the city of New York were not happening in an honorable way, and parties were having their private diaries and conversations and everything discussed in public in the open courtrooms. And he felt there should be a more better option, and therefore he started this collaborative practice of law. The key ingredient which you need to understand for now is that in collaborative practice of law, there is an agreement before starting the process between both the parties and their respective lawyers. Even the lawyers sign that agreement, that they undertake to assist the parties in getting a resolution, and should they not succeed, they shall withdraw from their respective clients' matter, this present matter, and the parties would be left to themselves to appoint separate lawyers for themselves. And there are certain lawyers who do only this practice, and therefore it's very easy for them to let go, and it's very easy for the parties to trust them, because they know that if they don't settle these lawyers are not going to make any extra bucks out of taking us to litigation. So they have more trust in the lawyers who do this practice only. And Lok Adalat, of course, we all know in India, we have Lok Adalats happening all over India. And in fact, there is a slight difference in Lok Adalat. There are two types of cases. If it's a permanent Lok Adalat, then in fact, that also is binding on the parties, whatever flows from that. However, in the other Lok Adalat matters, it is for the parties to decide whether they want to agree to a settlement or no. And there will be, I'm sure, another session where someone will guide us more about the deeper nuances between the two. Coming now finally to mediation. Mediation is the most popular, prominent process across the globe. Wherever it has been implemented, people have found great benefit from it. And today, people will give you some idea about 90% and all that being the success rate in mediation. But yes, but not the 90% of the matters go through mediation. It's about 53. But as I said, that 53 means then you have to also include non-binding arbitration and such processes which are used as part of mediation. Therefore, you have to share that data, statistics with these other processes like expert determination, neutral evaluation, and still mediation is 53% plus in just about every state in the USA and also in the whole of Australia and New Zealand also, and PNG also, Papua New Guinea. They are also really implementing mediation in a very successful way. Now, when we are talking of ODR, it is nothing but taking your whole practice of dispute resolution online. It's online dispute resolution. Now, whenever we talk to people, even forget ODR, but even if you talk about a simple thing like WhatsApp, Google, Zoom, several people have a lot of misgivings about one or all or some of these gadgets, these applications that we have available online. Now, these online services do have their own nuances, but people either are not used to having them and therefore have never used them and therefore find difficulty in getting across through them effectively and therefore do not propagate them and do not use them and dissuade others when they are asked to use them. Essentially, when you are looking at ODR as a lawyer, you will find that in any case, your back office is working online. Even just now, you are sitting at home doing things online. You are attending a webinar online. You write to parties through email, which is online. You send WhatsApp messages about rescheduling of your meeting, it's online. Text messages online. Everything is online. And still, we have some phobia about bringing that back office to the front office. And if you look at it closely, it's the same practice, which you are doing at the back office and are now bringing to the front office. Yes, lawyers who would rather travel, like me, I love traveling, would prefer to do things in a non-ODR way. If you say I've got a matter in Delhi, some mediation, then I would never ever suggest to do it online, only because I like to travel. But nowadays we are in a different scenario. Who wants to wait in line for 4 hours outside the airport just to get in and leave that much early to get to the airport and then probably spend 14 days at the other end and missing out on your meeting should, God forbid, you end up with a little fever, or at least it seems so. That being the scenario presently, it's always good to be abreast of the developments in this ODR field. And seriously, I'll tell you, it's no magic and there is really no reason to not adopt and embrace ODR. The phobia that we have about anything is usually in equal proportion to the ignorance of that thing that we are asked to go for. And if we already have some benefits coming from something else, some options, then we would rather stick to that. Like I get mileage points even if clients give the ticket. So my benefit is that. I like to travel. My benefit is that. And therefore, I would not prefer to go for ODR. However, Times are changing, and I'll tell you that ODR really simplifies your calendar too. You can get today also. You will see people are attending 5 different conferences emanating from different parts of the globe. But of course, everything else is in the cloud. So your time in your calendar gets really freed up if you go prefer ODR for getting your clients to resolve that dispute. That's one thing which people need to keep in mind. Now, let's look at the options that we have in mediation. Let's look at the options that we have. We have text messages. In the year 2003, when we were doing these competitions for online dispute resolution, text was just about the only thing we had. Audio also was rare in only in some of those rooms did we see something of that sort. But audiovisual was definitely out of the picture. We never even imagined that we, like today, would be able to see a streaming video of people. And therefore, I remember even Dilbert characters, Scott Adam, creator of Dilbert, he also said that I wonder how many people would like to see my ugly face for all the duration of the time that they are talking to me. Therefore, I do not see any value in streaming video. So that was the scenario then. Today, it's a given. Today, audiovisual, we have got of several formats coming from several places. Yes, people do again have issues about some or the other at some point of time or the other, but that's besides the point. Options abound. And today, therefore, you can do your ODR through text, through audio. Audio means through telephone. I do know some organizations in India, at least the name that comes to mind is ODR Ways. Now they have renamed themselves as Sama. You may even visit their website, sama.live, sama.live. They have a nice platform where you can register a case, and I do some work for them. All those are happening through the audio format. One thing you need to be aware of in choosing these options is that in India, firstly, our mobile phone connectivity penetration in the market is about 80%, and for computer it is about 45%. That being so, you may want to prefer starting doing things on the mobile gadget handset rather than be focusing on doing things through the laptop or computer. The other thing that you need to be aware of is that connectivity is another issue. Everybody does not have the same speed. Even just now, I got bumped off because of the storm and I had to move on to another service provider. So you log out, log in, again, get into the system. It takes a little time. So it's always good to have a low bandwidth platform, or at least some platform which allows that variation between the low bandwidth choices like audio and text and the high bandwidth ones like text with audiovisual or just audiovisual. And presently today we are in audiovisual with text. So you have the opportunity of sharing your thoughts with me. We can be interactive on the text platform, but on the audiovisual platform in the present meeting, that has been restricted. So you see, these options are always there for us to play with and see what fits the fuss. Now, the last two words are important to know only because I want to draw your attention, not that they are new to us. Synchronous is something which you do when the other person is online, and you can do it only when both of you are online at the same time on the same platform. Whereas asynchronous is something which you can just from your end shoot the message and that other person will read it when they can and reply when they want to, and we will see it whenever we can or want to or are able to. Again, there are several nuances about, like if you notice a slight difference between your text messages, the SMS that you sent, and your WhatsApp message. Our text messages, if you have switched off your mobile phone for 3 hours, let's say at 1 p.m., and if you switch it on at 4 p.m., all the messages which were sent in the last 3 hours will show the time of 1600 hours. Therefore, you can never know who sent the message first and when each message came in. Whereas if you look at WhatsApp, you may be keeping it off for several days, and still moment you switch it on, you will get a proper chronology of who sent the message when, on which platform and on which group. And some people may even send you on a group as well as individually. So you will get all those separate files available to you with the right chronology in all of them. And that's another nuance that you need to be a little aware of, so that you know which you would like to prefer. Because there are certain parties, and virtually it is all the parties who are in pain, who are sometimes not able to pause for a moment to appreciate what is really happening. They just see a gap of gray area where they don't understand, and they put in their own understanding of it depending on the mood that they are in. And usually when you are in a dispute, your mood is never ever positive. So you always have some finger being pointed at whatever is the other person's message, and anything that you don't understand, even when you type a message, you don't get a response, and you feel कि देखा उसकी बोलती बंद कर दी. So you have to be aware in online, these nuances will abound. And that's where you may want to consider the choices between synchronous and asynchronous. Usually, now we have all got the benefit of the Google Baba. So I will tell you, you may want to write down, there are people like high conflict personalities. Now, they especially, if you get them into a synchronous platform, they might be a little agitated, and therefore you might find a lot of stuff flowing in the air in those rooms. And therefore you may want to consider a little bit of an asynchronous platform for such people. And even if you do consider either, you may want to be in constant touch with them as a buffer between the two parties, so that things don't get aggravated beyond the point they already are. I will give you a little demo of one of the several platforms I may point out. When I started off in 1997 in the mediation field, nothing was happening then. In fact, even I looked at the training for some time but didn't bother taking the whole of the training. Then in 2000, I took the training, and then 2001, 2, I kept repeating these trainings. 2003, I took from Australia. But during that time, I came across this paper, and I asked that person later on. The paper was 107 and counting. And this was the count of how many ODR platforms are available across the globe for parties to resolve their disputes online. Now, mind well, this is 2003, 4. When I later on met the author of that paper in 2005 and asked the question, okay, what's the count now? I was told it is hardly 50, less than 50. And the reason was that that time we had a bit of a dot-com bust and all those things, other things also happening, because of which the popularity of these platforms went down. Probably they didn't know how to pitch themselves. Probably there were no takers. Probably there wasn't a bridge between the providers and the takers. So those who wanted it didn't know where to get it. And maybe we lawyers did not bother telling them that you have this option, probably because we ourselves didn't know about it. But anyway, now today we are at another crest of a wave, where in India itself, we have got half a dozen platforms which are available for parties to consider getting onto for resolving their disputes. And today I have before me a demo of one of such platform. It's Crack ODR. I may give you, let you in on a little secret that Crack ODR stands for CR is for Colin Rule and EK is for Ethan Katz. These are the two gentlemen who were the first two authors of books on ODR and are seen as pioneers in the field. Colin Rule has got a long bio. I wouldn't go into it. Professor Ethan Katz is in Massachusetts, Boston University. He is University of Massachusetts professor, and he has taken several initiatives. The latest one is ICODR, that is ICODR. In the earlier days, in 2003, ICODR meant International Competition on Online Dispute Resolution. Today, it stands for International Council on Online Dispute Resolution. You may want to get more involved and maybe become a member of that organization to get things uh, more interesting for you.
Could you please, in short, explain the conciliation process and why is it not brought much in practice as compared to mediation and arbitration?
Conciliation is something which really gives parties not only a resolution that they want to carve out on their own, but it also affords them the opportunity to enforce it should they require to. Usually it is hardly ever required to, because if I did not want to wear the shirt today, I would not get it ironed yesterday. If I have got it ironed, it's only because I wanted to wear it. And now that I have worn it, nobody is going to tell me that, no, you need to change. I mean, the wife apart. That being so, if you are going for conciliation, then you are carving out an outcome of your own free will. And that outcome, you don't need to, but if you want to or you require to, then you can definitely enforce it also. Now, when you have such a fantastic solution available, you have to understand that it even becomes not only efficient but also efficacious. Therefore, there is minimal wastage of effort or time or even money on legal fees. Therefore, if I am your lawyer, I would keep quiet about it till you point it out and force me to go for conciliation. If I am your lawyer. And that's a scenario that today we are not even taught about it so much. We do not have any great focus on it. If you even look at our parliament or the courts, you will find that there are hardly any cases. The first one I remember was of Svetla versus Burma or something. SVEDLA. That was, I think, the earliest ones in conciliation. And today, all the several amendments that you see happening and people commenting on those proposed amendments, conciliation, which is in part 3, is totally out of the picture, beyond the horizon. There is no mention at all. And I do not know why this is happening, but it's probably because we have never been taught about it. And even where we have been given some initiation into it, we are told that no, this is part of the Arbitration Act, therefore you can't do it without an arbitration, which is totally incorrect. Part 3 is a standalone provision. You can go for conciliation directly. And in fact, it works very good because the conciliator can be appointed by the parties themselves and can sit on it right away and get them to some understanding to the extent that they want to. And a resolution can be found and, if required, even executed for enforcement, which usually is hardly ever the requirement, because if parties didn't want to abide by their terms, they would not sign on the dotted line. So I do not know why, but I do not even expect it to happen. But now we should now forget about it, because conciliation is there, always available. But if people are wanting to go to court, then again we have the benefit of the Commercial Courts Act, which says that they just can't go to court before they first try out mediation. So whatever we missed out on conciliation, we get the parties back into the room through the Commercial Courts Act.
Can ODR agreement be clothed as conciliation agreement to make it binding under Arbitration and Conciliation Act?
That's not possible. You can't wear a nightgown and then say, I'm making a bed suit out of it. It doesn't happen. Jokes apart, conciliation process starts with a notice under the Act to the other side, inviting them for conciliation and inviting them to jointly consider appointing a conciliator. That first button on the shirt, if it is not proper, that if the notice had not been said, then down the line, whatever happens is ad hoc mediation, not conciliation. Yes, I do see some intervention likely from the Supreme Court at some point of time regarding conciliation, that it suffices if parties have a priori agreement to go for institutional conciliation if a dispute arises, and that would be sufficient to meet the requirement of Part 3, which says that you need to send an invitation and the other side needs to accept. If you have got this a priori agreement to conciliate for any future disputes, in my view, that is sufficient to meet that requirement. So that a little intervention would be required for clarification on that point. But otherwise, conciliation is possible only if you go through the stages mentioned in the initial 61, 62, 63 sections of Part 3 of the 96 Act. So what people often do is they mediate first, and then they realize that yes, we are able to get to a closure. Only thing is that the obligations under the agreement that we are contemplating, which we have actually already agreed on in principle, those are a bit spread over time, and therefore it is possible that someone may change their mind, someone may have second thoughts. Then what to do? So then at that time they agree to go for conciliation, and therefore they have already mediated it, but they now choose to have a proper conciliation process where they agree that, okay, now what we will do is lawyer for this side will send the notice and the other will immediately reply that yes, we agree to conciliation. And then this same agreement that you have arrived at in this mediation, you take it forward and redo it in the conciliation process. And therefore, it's only a question of spending twice over on the neutral and the legal services for the period, first in mediation and then in conciliation. But that's still pittance compared to the amount you would be spending in arbitration also and in litigation also. And that being so, that's one way of doing it. Some people do try to cut things short, but then, as I said, that if nobody is going to object about it, Mia Bibi Raji kya kare kaji? So if nobody is going to object about it, then everything flies under the radar, and therefore there is no issue. And mind well that conciliation and mediation both are confidential processes. Therefore, you will not find much case law also on that, because parties usually do things quietly. The whole purpose of doing mediation and preparing mediation and conciliation was to keep things quiet, and therefore also we suffer a dearth of precedents in this field. So I do not see how you can convert the mediation into conciliation other than restarting the process of conciliation from scratch once you have decided, once you find that you have a mediated agreement between the parties.
The next question is, a lot of the students would like to know, are there any online certification courses on mediation and conciliation, and where do they find them?
There are several of them. You can go to my blog, which is mumbaimediators.com, and there I have mentioned one person. His name is Mr. Bruce Edwards. I have not taken more than 2 days training under him, 1 or 2 days, but that was enough for me to find and note that he is a really par excellent trainer and someone with very deep experience. You need first an experience in these things. You can't discuss buoyancy. You have to experience buoyancy to be able to appreciate it. Therefore, I remember in 2003 also, I had this query about what is the difference between mediation and conciliation. And I met several people. My dad being a lawyer, I had asked him, and he gave up even without trying and said, hey, says, I know one gentleman, you should meet him. Come with me to Delhi next time and I'll introduce you to him. And he introduced me to that gentleman. He sent me some 20 pages worth of his notes on the difference between the two. I only ended up getting even more confused than I was earlier. So then I went to to Australia and sat into that conciliation tribunal to see exactly what conciliation is all about. And this, my friends, is something which you must do for yourself. Like you can't learn swimming like Sheldon tries to do it, sitting next to the TV and moving his arms and legs in front of the TV on the floor, saying that, well, I just have to then replicate it in the water. No, it doesn't work that way. You need to do it yourself. And therefore, I'm glad that you people asked this question, shows that you are very interested in the field. And you may want to look at this Bruce Edwards. But there is another very good motherlode of a site called mediate.com. They also run courses online and they are streaming. So unlike me, who had to earlier go for one of these trainings all the way to US, spend lakhs of rupees on travel, stay and blah, blah, blah. And also on the course fees. Today, the course fees themselves stand reduced to a certain extent because they are streaming courses. Live trainers are no more required, and you don't need to travel or bother about stay in Airbnb or any hotel. So these courses, I don't know exactly how much they cost, but I think it's about $400 probably. And there's another one streaming, not streaming, but a live course happening sometime in July maybe, which is about 50% more, probably about $600 or $700 US. So all these courses are available.